Well, good afternoon, everyone. If we have not already met, my name is Sarah Block, and I'm the Senior Development and Communications Manager at Brooklyn Legal Services Corporation A, or Brooklyn A. Thanks so much for everyone for joining us here this afternoon. We wanted to hold this training for community partners on the ERAP program, so that it's a way that you all can be informed about the program and answer questions for your clients or communities, constituencies. We're going to be holding a general training and town hall on Thursday. You probably have all seen that information already. I know Cypress Hills has already shared it out. Thanks so much. We have about 80 people already signed up for that training, which is awesome. And I know a lot more will join. So, we really just want to make sure that we're getting the word out about this program. And you all can help us do that. But we want to make sure that you're all well equipped to understand how it works, who's eligible. And so we are joined here today by Christy Ortiz-Lamb, who is the director of the Preserving Affordable Housing Program, newly our director, which is very exciting. And Zach Young, who is a staff attorney in the Preserving Affordable Housing Program. Christy, can you get the slides started, please?
Yep.
Oh, do you need, okay. All right, so I think most of you already are familiar with us, but just a quick overview of Brooklyn A. Brooklyn A advances social and economic justice and community empowerment through innovative, collaborative, neighborhood-based legal representation and advocacy. We represent low and moderate income individuals, families, small businesses throughout New York City. Our clients, who are 90% of whom are people of color, live in rapidly gentrifying neighborhoods where many residents and homeowners, small business owners have been displaced or facing displacement pressures and harassment. So we provide now for over half a century high quality, low barrier, neighborhood-based legal services and advocacy. So as you know, today we'll be talking about our work in preserving affordable housing and in tenant advocacy. And that work includes eviction prevention, anti-harassment, and fair housing claims. We help with repairs and restoration of essential services. But also we have programs in homeowner preservation. So that includes foreclosure prevention, deed theft, predatory lending, and bankruptcy. We also help folks resolve tax issues with the IRS in New York City. We provide transactional legal services for nonprofits and small business owners. And we are available to help your communities, our communities, Monday through Friday, 9 a.m. to 5 p.m. You can contact us by emailing us at info@bka.org for any of our service areas, and then we'll make sure that gets to the right place. Or you can give us a call at 718-487-2300. We're open for you all to be here as a resource and support. Next slide, please. Great. I'll be turning it over to Christy and Zach, who will be talking about the Emergency Relief Assistance Program, or ERAP. And then we'll be giving an update on the eviction moratorium and talk about tenant resources, and then we'll move into questions. So this is a nice small intimate group. And so we want this to be, a conversation with you all, and how we can help you to better understand the ERAP program, and also just kind of the general state of the moratorium and tenants' rights at this time. So feel free to ask questions at the end, or if you have any very pressing questions in the middle of the conversation, I imagine that Christy and Zach will be open to answering them. And with that, I'll turn it over to Zach first. Yeah, great.
So the Emergency Rental Assistance Program, or ERAP, what are ERAP's benefits? Households approved for ERAP may receive up to 12 months of rental arrear payments for rents accrued on or after March 13 of 2020, up to 3 months of additional rental assistance if the household is expected to spend 30% or more of their gross income monthly to pay for rent, up to 12 months of electric or gas utility arrear payments for arrears that have been accrued on or after March 13th of 2020. And payments will be made directly to the landlord or property owner and the utility company on behalf of the tenant. Who is eligible for ERAP? New York residents are eligible for ERAP if they meet the following criteria. Household gross income is at or below 80% of the area median income. On or after March 2020, a member of the household received unemployment benefits or experienced a reduction in income, incurred significant costs, or experienced financial hardship, either directly or indirectly, due to the COVID-19 pandemic. The applicant is obligated to pay rent at the primary residence and has rental arrears at their current residence for rent owed on or after March 13 of 2020. And the household must be at risk of experiencing homelessness or housing instability, which can be demonstrated by having rental arrears owed on or after March 13 of 2020. Where do you go to apply for ERAP? The application for ERAP can be found on the OTDA website. We've provided a link for that website in the slide. And applications are open right now. Applications for ERAP began on June 1st of this year at 9 a.m. And all applicants should go and apply immediately, regardless of their priority. There are 3 different levels of priority under the new ERAP program. For the first 30 days, priority will be given in the following order. First, to households at or below 50% of the area median income that also include a tenant who is either unemployed for at least 90 days, a veteran, experiencing domestic violence, or is a survivor of human trafficking, has an eviction case for their home pending in court, resides in a mobile home, whose community was disproportionately impacted by COVID-19, or who lives in a dwelling with 20 or fewer units. The next level of priority is for households at or below 50% of the area median income. And the last level of priority is for households at or below 80% of the area median income that also include a tenant with the conditions from the first level of priority. We have here 2 examples of how to determine the level of priority. For New York City, each borough has the same area median income scale. So the 50% of the AMI in any of the counties is going to be $53,700, and 80% is going to be $85,950. So if we have a family of 3 in Kings County with 2 adults and 1 child, and the first adult makes $25,161, and the second adult makes $12,200, and let's say the child has an annual SSD income of around $6,543.21. It's a total annual income of around $44,000, which is less than 50% of the AMI, which will automatically put them in the second tier of priority, unless they have one of the eligibility requirements to be listed under the first tier of priority. Example B just shows for the same family of 3, if they were to live in Broome County, in case anybody does run into a family that's outside one of the boroughs. In that scenario, they would be under 80% of AMI, but above 50% of AMI. The OTDA ERAP website does have the AMIs listed for both 50 and 80% of income for each county in New York State, with numbers for different household sizes. I believe from a person in a household of 1 up to a household of 12 individuals. So what do you need to apply for ERAP? Tenants who are applying for ERAP are going to need personal identification for each member of their household. They're going to need a social security number for any household members who have been issued one. And individuals do not need to have lawful immigration status to qualify for the program. So if they do not have a social security number, that shouldn't disqualify them for this program. They're also going to need proof of their rental amount. That can be shown through a signed lease, a rent receipt, a canceled check, or money order. And if there's no documentation available to show a rental amount, the ERAP program will accept an attestation from the landlord. The tenant's also going to need proof of residency and occupancy. That can be shown through a signed lease, rent receipt, utility bill, school records, bank statement, postal mail with the name of the applicant, an insurance bill, or a driver's license, and the proof should be up to date. Proof of the income to document their eligibility. They are going to need documents demonstrating their monthly income or documents demonstrating their annual income in 2020. If for whatever reason a tenant does not have that, there can be a self-attestation of income in certain circumstances, such as self-employment. For applying for gas or electric, they're going to need to have their utility bills available in the application. These are the 2 links for the OTDA website that will show you each borough's income, area median income for different family sizes from 1 to, I believe, up to 12. And then after the tenant finishes their portion of the ERAP program, the landlord will receive a notification, and then they will have to complete their own portion of ERAP. And the landlords are going to need a completed W-9 tax form, an executed lease with the tenant, or if there's no written lease, a canceled check or some evidence of funds transfer or other documentation of the last full monthly rent payment. documentation of rent due from the tenant, like a ledger or an attestation on the application, banking information so they can receive the direct deposit, and the property manager or owner or an authorized agent will be required to sign the application form and associated certifications agreeing that the information provided, including the amount of rental arrears owed, is accurate and does not duplicate a payment received from another program. And lastly, if a landlord does not respond to the ERAP application after they receive a notification that the tenant has completed their portion, can the rental payments be made directly to the tenants from ERAP? And the short answer is no. Payments provided through ERAP must be used to pay landlords for rent owed from eligible tenants, and those payments will go directly to the landlords and only directly to the landlords. If there's an issue, program administrators can contact landlords to inform them that additional information is needed based on the email/contact information provided by the tenant. If the tenant is determined eligible for ERAP assistance and the landlord cannot be contacted to provide necessary information, so the rental payment may be issued, the state will hold such funds on behalf of the tenant for 180 days. The tenants will receive written notification of available rental assistance, and tenants should share this information with the landlord, and if needed, may provide it to a court as a defense in any proceeding seeking a monetary judgment or eviction brought by the landlord for non-payment of rent accrued during the time period covered by the available ERAP payment. And now I'm going to pass it on to Christy for the housing update moratorium, rent relief, and eviction protection.
Hi, everybody. So what should tenants do if they're suffering from financial hardship? Of course, apply for the ERAP program if they don't have future ability. If they do have future ability, then they can apply for the one-shot deal. Also, for different charities around the city, we have a contact list for different charities, but I'm sure that you guys all do as well. Again, it's actual defense in the housing court case. If the landlord rejects the ERAP program, they actually can't start a case for 12 months, and they cannot sue the tenant for or try to get a money judgment for the outstanding rent if they reject the ERAP program. And then next is the moratorium. Moratorium has been extended until August 31st, as long as the person actually applies or fills out a hardship declaration. And the hardship declaration is until August 31st, which I just said, but then there's also a CDC issued moratorium, which has its own hardship declaration. It's a bit more complicated and it's more related to finances only. And so if the person hasn't been impacted in a financial aspect, then they're not eligible for the moratorium under the CDC, which is fine because New York City has added an added protection for people who haven't just been affected financially. And so the declaration asks tenants if they're suffering a financial hardship or if moving would pose a significant health risk. If either of the two applies, then the court case or even the proceeding, like the commencement of a proceeding is stayed, so the landlord can actually file the papers. So these are the emails where you could send your hardship declaration. It goes directly to the courthouse, and then they would know that the case can't be calendared in housing court, or it can't be filed. New York State courts are all virtual, except for those parties who are unrepresented and do not have access to like a smartphone or a computer. The court at times will allow them to come to the courthouse. This is generally only if they're in 3 different parts. The court attorney part, which is non-payment cases that were commenced after COVID, but that the tenant actually put in an answer. They can appear in person. Also, if the landlord is filing a motion to execute on the judgment, they can appear in person. And then Part Z cases, that means that the court is actually reinstating a case that was prior to COVID, and there is one attorney on one side who put in a motion for a request of relief. So those are the three types of cases. Generally, you cannot go to the courthouse, but if it's set for a trial or for a hearing, for example, an illegal lockout or an HP for emergency repairs, in those instances, you can also go in person. The court are processing only non-payment cases, two-attorney cases, and nuisance cases. Those are the only three types of cases that are being heard in court. And then any non-payment cases commenced after the start of COVID-19 where a tenant is not represented by an attorney, the court will offer them an attorney. And if the tenant rejects legal services, it still will proceed regardless of the fact that they don't have an attorney. Tenant rights in COVID pandemic. The COVID-19 Emergency Eviction and Foreclosure Prevention Act of 2020 is the reason why we have hardship extended until August 31st, 2021, or why we have a moratorium in the first place. So this requires tenants to complete a hardship declaration, but the hardship declaration does not stop a nuisance case where the nuisance behavior is still happening, or there was a warrant and judgment against the tenant prior to COVID. Then those cases can still proceed in court. But the execution of the warrant is stayed until August 31st if the tenant actually files a hardship declaration. If they do not, then they can be evicted any day. And then this is the information, which I hope you all have, where you can make direct referrals to us. You can email info@bka.org or just call our number and you'll be directed to one of our paralegals. Any questions?
Hello?
Hi, we can hear you.
Okay. So I was just wondering, I know there's going to be the info session for the general public Thursday at 6, but would there be a flyer that BKLA had provided that just kind of also summarized the information here real quick that we could hand out to constituents?
Yep. Yeah, we're in the process of finalizing one. We do have one. You can send
Okay.
out.
All right. Thank you.
You're welcome. And Sal, can you introduce yourself?
Oh, sure thing. My name is Saul Porter. I'm with the Staten Island Urban Center, which is a nonprofit in Stapleton, Staten Island. My apologies for coming in late. I was still at my other job and lost track of the time before coming here.
No worries. Thanks so much for joining us.
Thank you.
Thank you. Chrissy, do you mind taking the slides off so we can just see everyone? Yes. Sorry, Patricia, you asked, will this session be available? Do you mean, will the recording be available? If so, it will, yes, we can send out the recording of this presentation. And the Thursday's event will also be recorded. The English version, there's going to be simultaneous interpretation in Spanish as well, and we can share the English presentation afterwards. Okay, any other questions? Also, I guess if anyone that hasn't introduced themselves could either just put it in the chat or just unmute yourself to tell us where you're coming from, just so we can see who's in the room, that'd be great. Rosemary?
Hey guys, so I'm Rosemary Maldonado Wright. I work with Cypress Hills. So I have a question. I've had a handful of homeowners who have had nuisance cases from the beginning of the pandemic or even before the pandemic. Do you guys assist with cases like that?
We unfortunately don't, but we can provide a referral to, there is this attorney who actually helps us with pro se litigants to actually help them in filing their cases. So we can make a referral to him and then other legal, other organizations who could help with that.
How can I get that information from you? I have a specific homeowner that she's having a real hard time with her tenant.
Just send me an email. I'm gonna put my email in the chat. And you
Okay.
just send me the information, the contact information for the tenant, and then or the landlord, and then we can actually make the referral directly, or I can give you the attorney's information, and then you can make the referral yourself.
Thank you, I appreciate it. Okay.
So I think some folks are introducing themselves in the chat.
Yes. Yeah. Thank you for everyone for putting your info in there. Miriam, thanks for joining us. Anna, Patricia. It's great to have you all here. You know, as I said in the beginning, maybe for folks that came in late, the hope for this session was to, you know, this is kind of like a train the trainer session, so that you all can answer questions for your communities, your clients, your constituencies. So if you have any questions like on specific eligibility for the program, this is a great time to answer it. We'll, as you've probably seen in our many emails, we're holding a general info session on Thursday. That you should, you know, please do share with your networks. But this is a good time to ask our attorneys like any specific questions, any doubts, you know, and anything like that.
Just a heads up as well, we're actually assisting folks with doing the application, so you can make referrals directly to us for that. If you wanted to, we actually get, we can include it in our grants as a brief rep case. So
yeah, thanks for mentioning that, Christy. Great. So, I mean, it seems like the information is clear based on not having any questions so far. Oh, here's a question from Patricia. What if the tenant does not want to apply? What can the landlord do?
So the landlord can apply directly. The question is, how do they get the tenant's information? They can, it depends if they have a housing court case. If they have a housing court case, and then they can put in a motion to have the case conferenced, and then perhaps the court can kind of mediate the situation between them. You could also make the referral to us, and then we can speak to the tenant and see how we can encourage them to participate in the program, because it's sort of in their benefit to do it. So that's another way to resolve it.
Christy, does the landlord need to have the consent from the tenants to apply?
No.
And is there any reason from a tenant perspective why they wouldn't want to apply?
Because they don't want to pay the landlord. So that would be one reason. Maybe there's repair issues, and they're thinking that they are not obligated to pay the rent because of those repair issues, or because of some underlying defect in the apartment. Perhaps it's against the certificate of occupancy, or some other reason. But I think that's something that we could kind of mediate between the tenant and the landlord.
Okay. So folks, oh, go ahead.
Just wondering, a question. So if the tenant moved out, has moved out of the apartment, or say they abandoned the apartment, can the landlord apply for the program? Or
the landlord can apply, but you're not part of the priority because the tenant is no longer at risk of eviction. And so I don't know the likelihood of the landlord getting the award, particularly if they don't have the information for the tenant.
but the landlord can still apply.
Still can apply. Yes.
In a similar case where, so the tenant moved out, but moved in her family member to that apartment and left without paying the previous rent. How does that work?
So there's a number of ways that they could resolve it. The first, I think, is providing a lease to the new family member, and then that would allow that family member to kind of be on the hook for the previous rent. And so that would be a way to resolve it, giving them a lease, and then putting in the application for previous rent and I guess future rent.
Okay, thank you.
But we always have to remember that the person has to show that they've been impacted financially, right? And so if the person was working the entire time and their income never was altered, then it doesn't matter if the landlord applies. There has to be some sort of hardship.
So in the case that I'm thinking, the lady that lives, the tenant, was working, she wasn't paying, she's being a nuisance throughout, before COVID, during COVID, now. And then she moved in her older daughter to her apartment and she moved out. That's the understanding. And rent still hasn't been paid. It's over a year.
Generally, we don't represent landlords, so it's sort of a conflict to give this kind of advice. But because you guys are all providers, in that instance, they should start a civil case against the mother, where it would just be for the money. And then if there's an obligation to pay rent because there was a lease or some verbal agreement between the landlord and the tenant that was the arrangement, that she had to pay a certain dollar amount, that they could just start a civil case. And because they have the daughter within the apartment, hopefully she's forwarding her mail to wherever she's going. So you would be able to have kind of like a source for her service.
They actually do know where she moved to. They actually
that's
do have
perfect. So they can serve her.
Okay, thank you.
But I think the best situation is give the daughter a lease, but she has to be on the hook for the past rent.
Okay.
This program is available for undocumented immigrants. That's correct?
That's correct.
That's super exciting. Sorry, hold on.
It's okay. You live in New York City.
Proof that I'm in Brooklyn.
Exactly.
So I was looking at the application yesterday. So I saw that social security number is asked, but it's not required. That's correct?
Correct.
Okay. Great.
You could also put in your tax ID number. Any other questions?
Does anyone have any questions on the types of documentation that are required for the application?
And I think the system's back up and running. It crashed, I think, for a day or two. But it came right back up, which is great.
Okay, great. Oh, sorry.
No, I was going to say thank you so much, guys. I'm running out to another meeting in a few minutes, but I appreciate your help. Thank you.
Welcome.
Thanks for joining us.
Well,
Great. Okay, well, it seems like those are all the questions that we have for now, but if any other questions come up in over the next days, feel free to reach out to us. I think Chrissy put in her information into the chat. We can also distribute the recording of this event to everyone who signed up. And yeah, just, please keep sharing the word about Thursday's event, and just also just, general information about the program, and we will send out a program flyer so that everyone has it. And yeah, we thank you all so much for your partnership and for all that you're doing for our communities, and we'll see you all soon. Thanks, everyone. Have a good day.
Bye.
thank you.
Goodbye.
Bye bye.